Start. Similar had been the position as regards the testimony of PW-4 and PW-6 full stop. In fact, PW-4 Mahesh Kumar Sharma was not cross-examined at all, semicolon, and the cross-examination of PW-6 had also essentially been of a suggestion as if the accused appellant did not meet him on the given day, full stop. When the statements of independent witnesses PW-1, PW-4 and PW-6 are read together with the statement of PW-9, wife of the appellant, not only the circumstance of the deceased children being lastly in the company of the accused appellant is established, but further to that, it is also established that the appellant attempted to create a false narrative of accidental drowning of the children. Full stop. This false narrative, in the facts of the present case, becomes another strong link in the chain of circumstances. Full stop. When the facts established by the evidence on record and the surrounding factors are put together, the chain of circumstances had unfailingly been that the deceased children were lastly seen alive in the company of the appellant, semicolon. They died because of manual strangulation and obviously, their death was homicidal in nature, semicolon. Their dead bodies were recovered from the canal, semicolon, and the appellant attempted to project that they had accidentally fallen into the canal, full stop. In the given set of circumstances, when the deceased children were in the company of the appellant, who was none else but their father, and when their death was caused by manual strangulation, the burden, perforce, was heavy upon the appellant to clarify the facts leading to the demise of his sons, which would be presumed to be especially within his knowledge, full stop. Thus, the principles of section 106 of the Evidence Act operate heavily against the appellant, full stop. It is, of course, the duty of prosecution to lead the primary evidence of proving its case beyond reasonable doubt. But, when necessary evidence had indeed been led, the corresponding burden was heavy on the appellant in terms of section 106 of the Evidence Act to explain as to what had happened at the time of incident and as to how the death of the deceased occurred. Full stop. There had not been any explanation on the part of the appellant and, as noticed, immediately after the incident, he attempted to create a false narrative of accidental drowning of the children. Full stop. There had not been any specific response from the appellant in his statement under section 313 CRPC either. Full stop. Taking all the facts and factors of the case together, the chain of circumstances leading only to the hypothesis of the guilt of the appellant has been duly visualized and analyzed by the trial court as also by the high court. Full stop. That being the position, learned counsel for the appellant has endeavored to submit that an important link in the chain of circumstances, that is, motive, has not been established, and in that regard, reliance has particularly been placed on the statement of the wife of the appellant PW-9, who did not support the prosecution allegations about strained relationship of the appellant and herself. Full stop.